Judge Bernstein, I'm going to go ahead and open up the policy meeting this morning. I'm going to, if it's all right, Mark, just briefly hit the, I received your emails, and maybe everybody has it, but I'm just going to go through very briefly what we're going to be covering today. The York County Target 25 program, as well as the York County Investigative Grand Jury Report. And you can correct me, Mark, if I get any of this wrong. The recap of the recommended model domestic violence pretrial risk assessment tool, a recap of the proposed amendments to 18 PACS 2711, the certification of compliance, that the final draft, and then the academic review panel that met, I think, regarding the 8th edition sentencing guidelines. I get that all covered?
I believe so. That sounds great.
Okay, maybe all of that and more. Representative Krajewski, I think it's pronounced right. Judge Bernstein, haven't had a chance to meet you, so hello and welcome.
Morning, thank you, Judge.
Yeah, absolutely. So with that, I'll turn it over to the Executive Director to get us rolling.
Great, thank you, Judge, and good morning to everyone. Sorry for the technical glitch. I think everything has worked out, so thanks to Christy for resolving all problems like that. As Judge Bernstein said, and on the screen you will see there are 4 main topics today. York County, some issues raised by District Attorney Sunday from York County. One Target 25 program, which some members have expressed some interest in, a really successful program for repeat DUI offenders, as well as the very recently released investigative grand jury report. And so I was going to turn this over to District Attorney Sunday to talk about those kind of issues and then open it up for discussion. DA Sunday.
Thank you, sir. I appreciate it tremendously. Good morning, everyone. I hope that you all will indulge me for a little bit of York County this morning. I'm looking forward to a nice discussion and thoughtful dialogue. So we'll start out first with the Target 25 program. We were asked to provide a briefing on that. And so my first assistant district attorney, Tim Barker, who was instrumental in the development of the Target 25 initiative, is going to provide you with a quick briefing.
Good morning, everyone. Thank you very much for having me be here today to talk a little bit about Target 25. Some of you have heard me discuss this initiative previously. This initiative began back in 2011. Basically, it was being noticed, and I don't know if everybody remembers when there was a while in the law when the original 2004 DUI law, where we were imposing first, second, third, fourth offenses rather than first, second, third, first. And then all of a sudden, unfortunately, out of York County came the case law that went and put us back to first, second, third, first. And when that happened, it exposed a repeat offender problem in York County that specifically then Judge John Kennedy saw in his courtroom that really concerned him. And we, as part of our Criminal Justice Advisory Board, had a DUI treatment court subcommittee. And Judge Kennedy brought up what he had seen specifically in one case with a 4-time repeat offender, all pending bail, that had very high BAC levels and clearly was a danger on our roadways. And he's wondering, why is this individual? Is there no conditions, nothing happening, no accountability? So we went and did a deep dive into the data from 2010 to see where the problems were. And we discovered a couple very significant issues. First, very, very significant issue had to do with the length of time that would wind up happening from the summons process to when an original DUI arrest would occur to when actually a preliminary hearing would happen. The amount of time was actually far too extensive and far too vast that allowed individuals to rack up these repeat offender DUIs. The second issue dealt with bail. the different magisterial district courts, they were unaware of what the various cases were. And accordingly, we would keep getting ROR bails being handed out. No other types of conditions, nothing else done to promote public safety on the repeat DUI offender. So what we did in our data, we noticed that approximately 25% of our DUI offenses comprised repeat or multiple offenders. And DUI was very significant in York County. Almost a third of our caseload were DUI offenses. So this is a very high population of criminal offender having this many repeat and multiple DUI offenders that existed. And of the 25% of the repeat and multiple offenders, 25% of them also, it turned out it was a quarter and a quarter, were multiple offenders, had multiple pending DUI offenses that kept occurring. So what we did was we created the Target 25 initiative, with the 25 coming from the 25% aspect of the DUI offender population, that is the multiple offender population. And we developed an initiative that, first of all, had its roots in the 24/7 validated by NHTSA validated bail initiatives. And we wanted this to be a 24/7 type of concept. The second aspect that we need to make sure was that we work within the confines of the rules of criminal procedure, specifically all rules regarding bail. These are bail conditions. This is not sentencing. And the case law is very clear with those interpretations. So there were aspects that we knew we would need to do that involved recommendations, but could not be direct imposition to make sure that we kept the line between sentencing and pretrial bail. The third aspect is bail does have discretion. We knew we could not just apply something that was solely mandatory across the board when you do have to have consideration for different discretionary aspects by the magisterial district courts. However, there were uniform conditions that we knew would work for keeping the public safe and helping with keeping the offender safe from continuing to commit what can be a very dangerous crime with regard to repeat offender DUI. And finally, and this is the most critical aspect, this is a supervised bail initiative. So we work through our adult probation services, specifically our pretrial services unit. And if we did not do so, we would not be able to go ahead and have the success that we have been having. So how does Target 25 then work? Basically, at the time of the arrest, the officers, with the assistance of our sheriff's department, go ahead and see if this is a repeat or multiple offender within the 10-year look-back period. We do not do lifetime, the reason being that since the 10-year look-back period is the governing aspect of law for repeat offenses, we decide to stick within the confines, of course, of what the legislature had put forward. As I noted previously, we've been very, very cognizant of legislative and rule of criminal procedure requirements. Upon seeing that an individual is a repeat or multiple offender with pending DUI offenses, that individual is then brought to central booking. At central booking, that is where we will go ahead and we are a blood-only county, which is very, very, very critical because we are then able to capture all the various drug impairment offenses. And we have a very serious DUI drug problem in York County. It's very serious across the Commonwealth, but it is especially so here in York County. We are going to have all our 2020 data in April, but one of the things we know from tracking through the year so far, while our DUIs overall went down in large part due to the closure of of bars and some of the ability to consume alcohol while out, Our DUI drug offenses did not see that type of decline. In fact, we have seen a rise here in terms of opioid DUI and methamphetamine DUI in York County, and marijuana-related DUI. And because we do blood testing, we actually capture delta-9 THC and 11-hydroxy levels, the active levels showing active impairment. They remain very high. They total over usually between 27 and 30% of all of our repeat multiple offender DUIs. So that also the active impairment issue it's a problem. So after this, what happens then is the defendant is preliminarily arraigned. The summons process is not used. They are an immediate danger to the public based upon their recidivism. This does not apply to first offense DUIs. Again, this is only for repeat and multiple offenders. And so what happens is a preliminary arraignment occurs. At the preliminary arraignment, what then takes place is bail conditions are imposed that do include Target 25 bail conditions. Standard conditions that are involved with Target 25, they include alcohol monitoring bracelets and or urine testing, and that testing does include alcohol and drug panels. We get into some specifics with what is the most appropriate usage for the checking of impaired substance based upon what the underlying nature of the DUI may be. We also do some step downs as well from 24/7 alcohol monitoring bracelets to weekly random urine screens based upon also durations of compliance. So there are some different aspects with that, but those are standard conditions that occur on the front end. And they're also assigned to supervised bail. So they have to go through intake with a supervised bail officer. Then as part of supervised bail, they are encouraged to complete as soon as possible their drug and alcohol evaluations. And then we have an incentives program whereby if you actively engage or enroll in drug and alcohol, the recommended drug and alcohol programs, you are entitled to incentives then upon the time of sentencing. So those incentives include full, now what we would call RP sentences back when this started, full IP sentencing with no incarceration concerning fulfilling the sentencing requirements. So we've really tried to incentivize getting early into treatment. We know how important and valuable that process is. And the probation officers work very carefully and closely with all the defendants to ensure that they are engaging in those services. The other benefits that happen, however, are the other residual ones, such as we have many veterans that wind up having repeat or multiple offenses. Their veterans are hooked up with appropriate veteran services. We work on engaging individuals with employment so that we can increase our employment opportunities. There's a whole host of recommendations and guidance for services that can occur based upon having this contact with a probation officer being on supervised bail. Now, one of the things that we do in our office, right away, every Target 25 file is flagged, and we do an immediate rapid screen. And that rapid screen not only goes through the hands of our paralegals to get police reports and information such as that, and especially pulling the toxicology reports, our case managers looking at the criminal histories, most importantly, the driver histories, our victim witness coordinators to begin identifying that there are who are the victims of crime, if there are victims of crime in a given DUI offense. It finally then comes to me. And I still, after all these years, personally review every single Target 25 DUI file. And then I do upfront screening to see if the individuals would be appropriate for DUI court, appropriate upfront for RP sentencing, I start to give initial advice based upon the data. Now, some of the DUI court decisions or further decisions require further data, and I'll make notes of that in the file. But those cases that clearly are identifiable as DUI court eligible, I then have them scanned over the preliminary hearing packets, and we get those down to probation so that they have those packets. So if an individual does apply to DUI court, they are fast-tracked and automatically put into DUI court. So we really have been able to fast-track the entry. Based upon doing this methodology, we begin with initial aspects of breaking the cycle of abuse or addiction with alcohol and or drugs as early as days after the time of the DUI incident. And we do have the follow through then through all of the early phases when it's most critical to go ahead and have the rehabilitative techniques. And what we have seen through the years, and I'll just mention, we have a lot of data. I know this is a policy meeting, and unfortunately, the 2020 data, the way that it works, we'll have all that crunched in April of this year. And then we have to do some deep dive comparisons between the 2020 data and seeing the impacts of COVID-19 versus the 2019 and 2018 data to go ahead and have that full crunch. When we're done with that, what I have suggested to District Attorney Sunday was we can send a full data report to everybody as a follow-up. But just in general, a sustained significant aspect of what we have seen is, first of all, as a bail initiative, we are seeing success rates and appearances that run as high as, on average, 96% appearance rates. The second thing that we are seeing in terms of no other infraction type aspects, we are seeing overall around, on average, an 83% compliance rate through the years with these, with the conditions of Target 25 bail. We are seeing many people engage and enroll and remain so with their drug and alcohol rehabilitation and treatment, with also employment. We're seeing successful numbers in that way. And then most importantly for public safety, we used to average around in our victim stats, vehicular crime, specifically DUI crime, used to average between 18 and 20% of all of our victim crime in York County was due to DUIs. Now that has dropped to where it has been flowing between 6% and 9%. And that has been sustained since we began the initiative in 2012. The first year in 2012, we decreased to 14%. The next year, we decreased to 6%. Now, since that time period, it's gone between 6 and 9%, and we've continued to maintain that rate. Now, 6 to 9% is excellent compared to 18 to 20%. We're still analyzing things, though, to see how we can go even lower, what we can continue to do even better. One of the interactions that we have done as we've changed within our office is we do not have central court in York County. We have 19 magisterial district courts. We have to cover a lot of ground. We've redesigned and overhauled our office to try to get more ADAs to preliminary hearings to continue to improve upon and have the degree of early intervention and early interaction so that we can go ahead and continue to best protect our public, rehabilitate individuals, and create a better and safer York County community. So that, in a nutshell, is quite a bit of a soup to nuts brief dump of what we do for Target 25. But that, in a nutshell, is how things work. And again, we have a lot more, the long versions of everything that we have, we can fully provide to everyone, but that in a nutshell is what we do.
Well, great. Thank you very much. I think we'll open it up for questions or discussions. I will note that in the packet of materials and the information we posted online, we found an old case study, and even in the first couple of years, there was tremendous improvement, and it's great to hear that sustained over nearly a decade. So really impressive program.
Let me jump in here real quick then. Thank you, Tim. And then I will, do you want to hang here a second?
Yeah, Mark.
We'll see.
Yes,
Yeah, I did have a question. I didn't know if it was
Senator
appropriate.
Street, please.
Oh, you're back.
Yeah. One, it sounds like you've done a great job with your program. One of the things that was interesting is you said for your marijuana DUIs, you have a methodology for determining active impairment.
That is correct. We do blood testing, and the reason why we run a full alcohol and DRE drug panel is our standard DUI testing. We use a private lab, and we've devoted the money and resources to utilizing a private lab because of, quite frankly, the significant DUI issues that we have in York County. We always ranked as one of the highest DUI counties in the state. We always had a large number of fatalities, and we saw large and growing issues with DUI drug cases. So the private lab does break the toxicology down into delta-9 THC levels, as well as 11-hydroxy, the active metabolite levels. So we're able to get full toxicological reports, litigation packets, et cetera, to go ahead and proceed through trial.
So you do have a way of determining whether the difference between people who have sort of cannabis in their system, and the people who have active impairment.
That is correct. Yes. They also in blood toxicology, they will separate out delta-9 carboxy THC, which is the inactive metabolite. That will be separated out. Quite frankly, if all we wind up seeing is delta-9 carboxy THC, and we're not seeing anything else, those cases we're not pursuing those as DUIs because it's the inactive metabolite only. That's why it's so important to know what the active ingredients are and why. I mean, blood testing for DUI is really so critical if you really want to get your accurate answers as to, number one, if the individual is truly impaired. The second thing is knowing what exactly occurred here. Can you imagine having a crime where you're not trying to figure out what exactly happened? We don't do it in any other area. So why do we skimp in the area of DUI? We've been able to discover what the actual root sources were of potential impairment that an individual has, and then provide that data and information over as part of drug and alcohol assessment and review. So we're very happy with what we've done. It was a real-time commitment. It's also a financial commitment. We are able to attach blood draws, the toxicology results as part of court costs, but the reality is it's a commitment that really counties should be making. This, if anybody that's had to, I know some of you have sat with the families of individuals that are victims of homicide by vehicle while DUI. It is so tragic and can be so random. It really is what drove Judge Kennedy to want to really tackle this significant issue in the first place. So I'm sorry for going on about that.
No, it was very helpful for me, but I don't want to belabor it too much today because I don't know it's as relevant to what the commission is doing, but would like to get some of the information that you are using in terms of your standardization, because there is an appetite in the General Assembly to standardize how we deal with marijuana, DUI, and incapacitation statewide. And certainly, it's no secret to folks that my colleague Senator Laughlin and I are looking at how we deal with marijuana laws in Pennsylvania in a more comprehensive way, and would love to at some point arrange a time maybe with DA Sundays with his support, would like to talk with your office about how you can help us standardize the process across the Commonwealth, because you appear to be at the cutting edge of this.
Well, We absolutely are more than happy to. It's something that we strongly believe in, and absolutely will help in any way possible.
Thank you.
Tim, this is John Rago from Allegheny County. First of all, congratulations to you and Dave for this. It's a remarkable program. I'm curious, the private lab you use, is it NME in Philadelphia, or I'd like to know who they are?
We use NMS. Yeah, NMS labs in Montgomery County. Yep, that's who we use. We actually we started to use them. So I've been in the office for a long time, 23 years next month. And we started to use them because defense attorneys were using them.
Yeah.
And of course, they were coming in and having more accurate results than what was coming out of the hospitals.
Right.
And when the law changed and back in 2004, and with what we were seeing as already drug-related homicide by vehicle or DUI cases, we made a commitment at that time that we needed to create better DUI drug protocols, especially for blood testing protocols. And then it continued to evolve through the years. And I don't know if you remember back in 2007, when there was the proposed change by the Department of Health to only have forensic toxicological testing.
Right.
So our local hospital said, we can't meet that standard. We want out, you already use NMS labs for some things. We will help you facilitate getting the samples to the lab, but we don't want to be involved with DUI anymore. So we worked out with all of our hospitals over a series of meetings and with NMS labs, the comprehensive aspects. And so our current protocol has been in place now since I believe it's been 2010.
Yeah, I'll reach out to learn more. Michael Reeders runs that lab. He's a friend of ours, and I've been talking with DA Zappala about this. It's remarkable work, and I don't want to dig too deeply into this, but I'll get back to you and David to talk more about it. But thank you for this. It's wonderful.
Absolutely. Glad we could help with providing some information. Thank you so much.
Representative Stevens.
Thanks. Tim, good to see you again. Hope you're doing well.
Good to see you.
The presentation was terrific. You know, we heard this in the House Transportation Committee, and I was so impressed. It's one of the reasons why I thought it might be beneficial for this group to hear about what you guys have been doing in York County as it relates to DUIs. I am also glad that you corrected the record there for Professor Rago that company's not in Philadelphia, because they're actually in my district in Montgomery County. NMS is terrific. I've known them since my days in the DA's office. We used them for all our toxicology when I was a prosecutor. I wanted to steer away from that though and move over to the alcohol monitoring piece. Could you dig in a little bit on that and just share with the group how that works and just, you know, the technology that's involved and how effective that's been as a part of your overall program?
Yes. So the 24/7 alcohol monitoring, so we use a private vendor, and it is a bracelet that also has the capacity for electronic monitoring. So if there is, as part of an RP sentence or something of that nature, that there would wind up being a house arrest component, that the same bracelet can accomplish both goals. And so that's the technology we use. It basically is detecting alcohol at certain levels. If so, it will go ahead and it will send a signal back. And this is a really rough computer overview. Sends a signal back to the vendors, and then that will get reported over to probation. And there have been, when we began, we had concerns about costs, because we do not want to do something that was going to be cost prohibitive. We, you know, already there are a number of costs and fines and fees associated with DUI offenses. We did not want to compound any aspect. One of the things that our vendor has done, and they'd be better able to, along with probation, to speak to the minutia of these details, but they worked out what they call indigent beds to help out with costs concerning the alcohol monitoring bracelets. One of the hopes that we had early on, that Judge Kennedy specifically had, And why we had to go to the incentive aspect was that having these early requirements, not only would that go ahead and lead to earlier rehabilitation and breaking the cycle of impairment, but also would encourage earlier aspects within the criminal justice process of having defense attorneys bring defendants into court to go ahead and have pleas imposed. That has not happened as fully the same way, which is the reason why the incentives program became all the more important. And we're very cognizant of what the fees can be. And that's why we also will start to use an interplay between the alcohol monitoring bracelet and the random drug testing. Because if an individual is doing well for a long while, but especially if there was also issues regarding drug usage, there's drug abuse issues, the random drug screens actually will be in sometimes the better aspect up front. So probation does an interplay. They have the ability to go ahead through their monitoring to see what will be best. But we have found a lot of success, especially with alcohol abusers and those who are addicted to alcohol, with the alcohol monitoring bracelet. It has served very, very well as a 24/7 monitoring option for us in York County, and as part of the full scope of services we provide. I would again go back to as well, this is a supervised bail program. What has made us so successful, we fully believe, is how we've incorporated everything together within the confines of bail law. So we're not sentencing people, it's bail law, but it has been very, very successful utilizing these tools.
Great stuff. Thanks so much.
Hey, Tim, we have to move on, and I know DA Sunday has to leave us at 11, so we want to get to the other topic. But thank you so much for the information. And if when you have your more recent report, if you could provide that to us, I'll make sure all the members receive that. So thanks very much. And for the members' information, on an annual basis, the commission receives about 20,000 DUI sentences, which represents roughly a quarter of the sentences we receive. And we know that there's another roughly 20,000 ARDs for DUI. So this is a big, a big part of the work of the criminal justice system. And so I really appreciate the chairman and DA Sunday willingness to sort of put this on the agenda for discussion. And with that, I'll turn it back to DA Sunday for the second issue.
All right, thank you very much. I appreciate that. And I'll try to do the best I can to be succinct with this explanation. With the timing and the complexity of the issue, I have no doubt that some questions may arise that will require sort of, out of this venue conversations, and I'll be available to talk to anyone anytime about it. But we thought it was important. Yesterday, we concluded 2 days ago, we concluded a 2-year-long investigative grand jury on the death of an individual in York County Prison. And by way of background, very simply, I see there's a slide up here. Thank you for putting that together. But long story short, Everett Palmer Jr., 41 years of age, African-American male, lived primarily, he grew up in the state of New York. And all we knew one day is that he died in prison custody. And we knew nothing about him other than the fact that he had an outstanding DUI warrant and that he was picked up in Lancaster County on an outstanding DUI warrant. He came to York County Prison. He was screened at the prison. He was placed into suicide prevention protocols at the prison, and which incorporated 24-hour observation of him. And after about 36 hours or so, he started to really decompensate in his prison cell. He was walking circles in the cell, started ramming his head against the wall in the cell over and over again. And then finally he was extracted after being extracted from the prison cell by the prison CERT team. He then pretty much lost consciousness and died. And so right off the bat, obviously it was a very serious set of circumstances. And what really took this to a different level was a few weeks after, when the toxicological report came back, he had methamphetamine in his system. All right. And it's important to understand what his actual, what his cause of death was listed by the coroner. And so I want to be specific about that. And I want to read that real quick. And then this all ties into ultimately the grand jury recommendations that I wanted to share with this group, in the hope that we can take a horrific tragedy and potentially turn it into something where nothing like this happens again. I know it's lofty thinking, but so with that being said, I just want to pull up here real quick where's the,
I'll get the short version for you.
the short version?
Yeah.
Oh, it's actually in the intro.
Yeah.
All right, here. Sorry about that. It's a 174-page report. So that being said, okay, so the cause of death from the forensic, from the pathologist was complications following an excited state associated with methamphetamine toxicity during physical restraint, with a contributory factor of probable sickling red cell disorder. So that's a complex cause of death. And considering the fact that it occurred right after a cell extraction, we decided to take a very deep dive, and essentially we went on a 2-year journey that brought us to know a lot of very sad things about Mr. Palmer and about his life. And what we discovered from this was it was a tremendously sad case of untreated mental health illness, and also serious substance abuse issues that all was untreated. Mr. Palmer he got out of the military in around 2002-ish. He had mental health issues in the military. Shortly thereafter, he wound up in a VA hospital receiving mental health treatment. After being released from the VA hospital, he kind of floated through life a little bit, and then ultimately ended up in a place where he was abusing a lot of drugs very seriously, including prescribed Seroquel, lithium, and Thorazine in combination with daily marijuana, in combination with a fifth of Jack Daniels almost every single day, cocaine, and nonstop steroid use, which ultimately landed him in Lancaster Hospital with organ failure. That didn't stop him. He kept using and abusing drugs, and ultimately he ended up on about a 4 or 5 day meth binge that ultimately landed him in York County Prison. So the facts are detailed. They're in great detail for anyone to review in the grand jury report. But I just wanted to give that very basic synopsis as we continue through here. So as we progress through the grand jury, we realized that there was so much more to this than what met the eye. And what we found, and what the grand jurors found, was a tremendous sense of just tragic sort of awareness about how does someone who has mental health issues of this nature, that gets a DUI and gets picked up on a DUI warrant, ultimately end up dying in a prison. And so we took a deep dive into the mental health side of the prison system. We took a deep dive into the substance abuse side of it with regard to what's available, what's not, for people that find themselves in this scenario. And so I think the best way to do this is to read the recommendations to the group, and then just start talking about the recommendations. And some of the recommendations apply directly to the work of the commission. So the first few recommendations are very quick, and they're sort of they're directed in a micro manner towards the prison itself, and then they get broader as we work through them. The first recommendation, and also by way of background, Secretary of Corrections, Secretary John Wetzel was, and this is all in the public grand jury report, was one of our witnesses, and he provided expert testimony with regard to recommendations to the grand jury. He also was a part of our discussions yesterday with the media on this, and he's committed to working with me and the York County community on trying to implement some of these changes in the future. So the first one is that a negotiator or a de-escalator should be engaged prior to a cell extraction. Basically, where that comes from very simply is prisons are understaffed, and you can train inmates to actually be negotiators and de-escalators, and there's a lot of good that comes out of that. And so that's very simply sort of that recommendation number one. And again, this is all detailed in the report. Recommendation number two, medical staff should be required to be present prior to a cell extraction. Number three, EMS should be summoned to the prison prior to a cell extraction. Number four, the York County Prison should reconsider the use of electric stun devices during cell extractions. Number five, and here's where we get into some places where maybe Senator Street can help us and the other representatives and legislators here. But number five, an inter-county database for inmate drug and alcohol and mental health issues should be developed. That's very important because there are inmates that are in county prisons all over the state that find themselves very shortly thereafter in another prison. And one of the very main takeaways from this is the fact that prisons have next to no information about individuals when they land there. And the prison can only respond in accordance with the information that they have. And so a lot of the recommendations center around ways to make sure that the prison has the information they need so that they can make sure that the inmate receives the proper treatment and care. Under these circumstances, if the prison would have known that Mr. Palmer had such high levels of methamphetamine in his system, then a lot of things should have been different. In particular, they viewed what was happening with Mr. Palmer as if he had serious mental health issues, which he did, but they viewed it only through the lens of mental health. They didn't take into consideration the fact that he was high on methamphetamine and what that actually does to your system. Moving on. A presumptive drug screen should be conducted upon an individual's admission into a prison. That's very important. And Secretary Wetzel and I went back and forth on that. And the reality is, our thought is there could be some method in place where, an inmate signs off with the knowledge that this will not be used against you criminally in any way. We just need to know what's in your system so that we don't put you in a position that could cause a tragic set of consequences like this. And so we can come back to that. Number seven, prison staff should develop and implement trainings on how to recognize developmental disabilities. Number eight, communication between the York County Prison and behavioral health systems should be improved. Number nine, the use of previously prescribed medication should be continued upon entry in the York County Prison. Number 10, crisis intervention team training should be expanded among prison staff. Number 11, prison inmates should be trained as certified peer counselors. Number 12, I'm sure we'll have questions about this. Medical assistance benefits should be continued during pretrial detention. 13, comprehensive drug and alcohol treatment programs should be developed at the York County Prison. Recommendation number 14, again, I send this over to Senator Street and others. The provisions of Title 37 should be updated. And there's a whole explanation to that. We can come back to that. Number 15, criminal justice initiatives in diversion should be pursued and expanded through use of risk and needs assessments and the sequential intercept model. Number 16, collaboration and partnerships must continue between government agencies and healthcare and service providers. Number 17, the critical need for housing, especially among those needing mental health treatment, must be addressed. Mr. Palmer had, and every single of these recommendations ties to the life of Everett Palmer and what ultimately led to his death. Number 18, improve information sharing between intra-county and inter-county government agencies and healthcare providers. Number 19, probation services should conduct risk needs assessment screening to assist magisterial district courts in making initial bail determinations. Number 20, and we say that because Mr. Palm, well, we can come back to that. Number 20, motivational interviewing should be used by screeners at the sheriff's office, probation services, and the York County Prison. Number 21, drug screenings should be expanded to assess substance abuse issues. Number 22, a co-responder model should be adopted and crisis intervention practices should continue throughout law enforcement, the York County Prison, and the Probation Services Department. 23, establish a York County Wellness, Diversion, and Reentry Center and expand local behavioral health services. Number 24, criminal justice initiatives and behavioral health services must be properly funded, and a criminal justice reinvestment strategy should be developed in York County. So I know that was enough for probably a few months worth of conversation. And, you know, my thought is that if there's anything that can come out of this that we can utilize to make sure that tragic deaths like this don't occur again, then we want to do what we can to do it. You know, I feel like that the complexity of some of these recommendations are such that, you know, if anyone wants to have a discussion about it separately, we certainly can go through everything. That's why I provided the report to the group. You know, at the end of the day, maybe this goes nowhere, or maybe there's recommendations in here that don't result in any change. I hope that's not the case. But I felt that the need to share that with the Sentencing Commission as a fellow member, and considering this occurred here, you know, in my home. So with that being said, I'm not sure, Representative Stevens, if you want to have questions or commentary, or what your thoughts are.
Well, I did have a question, although it's Judge Bernstein's show here for the policy committee. So,
Yeah. Oh, sorry, Judge.
Okay, I'll take charge. Representative Stevens, did you have something to say?
Hey, thanks. Dave, this is really great work. And it's sad that, you know, it took a tragedy for this deep dive, but, you know, certainly we hope to make something positive come out of all this. I know last session I began calling for a JRI 3 to really look at pretrial issues. And this really, I mean, you guys are doing a lot of this stuff already, as we heard through the DUI process, by having supervised pretrial and, you know, supervised bail and things like that. You know, and that's the area of the JRI 3 proposal that I've put out there is let's get a working group together to look at pretrial issues. And it just, in my humble opinion, we need to do a better job of identifying those folks who've got either mental health issues or drug and alcohol issues, and get them in a path to either recovery or get them the help that they need early on, and get them to a path to success, rather than waiting for the whole criminal justice system to, you know, work its way through the process, you know, which oftentimes can be a year or longer later, to get these folks the help that they need. So, you know, I'm hopeful that the work that you guys have done in York County will help be a catalyst towards that, and that we can really begin to divert those folks who need help, not, you know, incarceration or punishment, into programs that can get them the help that they need. So thanks for sharing this, because I think it'll really help highlight the need there. Thank you.
Does anybody else have any comments? Senator Street?
Yes, look, I think the DA Sunday, I think the idea of an inter-county database is something that the General Assembly should definitely take a look at. I'm certainly willing to work with your office on that. I'm glad you brought it up, as well as sort of inter-county cooperation in general about the profile of what's going on with defendants. And finally, I do also, I'm interested in having a deeper dive discussion with you about the sort of a form or some kind of disclosure that can be made by defendants sort of disclosing what's going on with their toxicology without it being admissible, and sort of working with the you as a district attorney's office to sort of figure that out, where the appropriate lines are for that is something I'm definitely interested in. I think those are very much common sense solutions, and applaud your sharing this with us.
I appreciate that. And the toxicology was so important because, you know, we, through this process, we've all become, you know, quasi experts in what methamphetamine does to the body, the human body. We have not had a big meth issue in York. We've been obviously decimated by heroin and opioids, but now meth is just working its way through like locusts. And what meth does to the human body is so vastly different than opioids that, you know, you have to take that into consideration when someone's in your care in a prison cell. And so I think that that's just very important. I think the other thing is all of these recommendations are tied not only to this specific situation, but on a larger scale are all tied to community safety. Everything here implemented directly impacts public safety and decreases recidivism if done correctly. And so I appreciate your comments, Senator. I appreciate it. And we will set up a meeting and we'll get those conversations going. So thank you so much.
Yeah, thank you. And I'm looking forward to the conversations.
I had a couple questions. Good morning. Thank you for the presentation. And I'm sorry to hear about this tragic situation. Sounds like you definitely deserve better. My two questions were, one, could you expand a little bit more about the co-responder model that you had mentioned in your recommendations? And then the second question I had, I'll just ask it now, is in regards to also training other inmates to be peer counsel specialists or being able to de-escalate or address the crises. Obviously, there's an incentive in them being able to de-escalate a situation, but are there other thoughts or suggestions to incentivize inmates participating in that training that may be in regards to their own sentencing or other things like towards their own credit score in regards to being inside?
So to start with the topic of the peer counselors, I think that that's more of a question for Secretary Wetzel. He felt very strongly about that, and he viewed it more through the lens of just making the environment overall better. When someone is involved as a peer counselor, it increases their self-esteem. It allows them to help other inmates, and it's just positive all around. Inmates oftentimes, this shouldn't come as a surprise, obviously may react better to a peer counselor than sometimes a CO. And so there's a lot of good that comes out of it. I just think that that's a question that we would just have to explore a little further
Dave,
with him.
So, and I've
DA Sunday, I'm afraid you froze.
Unfortunately.
I just wanted to give a follow-up with that. County prisons have more difficulty than the state system due to the duration of time in which the
Hold on, did we lose you guys?
We have you now. You've been in and out. I think the
Yeah.
distance is impairing the connection.
Okay.
Let's see here.
Impairing. Nice play on words, Mark.
Thank you.
Too. So I apologize, but
This is all my stuff now.
We have
Bear
you.
with me just 1 second here real quick. What is going on?
okay. Are you able to hear us now?
We can see and hear you.
All right, go ahead.
Okay, terrific. So this is by way of an update. So when Secretary Wetzel testified, he acknowledged that it's easier to do that methodology in the state correctional system due to the length of incarceration of inmates there versus a county facility, which by its very nature will have shorter duration. But in talking with our York County Prison warden yesterday, who indicated to us he is hopeful that many of the aspects that involve policy and procedure changes within the York County Prison, that he can have those procedures implemented, those changes implemented within the next 6 to 8 weeks, and begin a program that may have a modification whereby you're having individuals who may be reentrants, where you can have all ex-offenders potentially come in and be paid consultants within the prison and working out aspects like that. So while you may not have inmates that have the duration of stay to go ahead and get all the training and get the facilitation necessary, instead you work with individuals in the community who are already very actively involved in our reentry, who would then go ahead and be able to help to perform that service. We have a very active local reentry coalition. I'm co-chair of it, and our warden just devoted part of the prison to now being converted into a reentry area to go ahead and work with inmates who are going to be reentering into the community. So that's by way of update and how we may need to modify that recommendation to fit the county model.
And with regard to the co-responder model, so essentially, and again, we go into great detail in the report about this, but under the co-responder or under the umbrella of the crisis intervention team, and if you don't know about a crisis intervention team, it's critical to understand what that approach is. The co-responder model emphasizes stabilizing an individual with mental health issues within the community so that their mental health needs are met through medication or treatment rather than entering the criminal justice system. And so we look, for example, at a crisis intervention team. And if you're not familiar with them, crisis intervention training, what happens is, let's say there's an incident in the community and police officers are trained to deal with mental health issues. And it's in a manner that's different, obviously, than they would deal with another person. So if they interact or encounter someone that's experiencing a mental health crisis, they can then request someone from MHIDD to respond to the incident. And so they essentially have what's called almost a warm handoff, right? So the police officer or the CO can calm the situation down. And then at that point, as a co-responders, the crisis team then comes in and essentially it's a handoff to them with regard to that specific individual. And so that's in a literally like a 30-second nutshell, and we can go into much greater depth about that. That training and that model is absolutely critical to properly handling individuals in mental health crises in the community.
Yeah, thank you. I agree. Thank you for that explanation.
Dave, they've started some of that here in Dauphin County. RDA in partnership with the Attorney General Shapiro, they have co-responders now with embedded in various police departments to start that process in I think 5 or 6 of our larger police departments. So that is rolling out here. It's part of the Stepping Up initiative. Again, Secretary Wetzel was instrumental in that here. But yeah, I think that's the way we're going to see things unfold.
I appreciate that, Judge. We have 4 departments. Do we have 4 departments?
It's 4.
4.
2 are going to share one in Hanover.
And what we found is really the biggest hurdle is funding. And so funding is the biggest hurdle to getting this done.
Hey, DA Sunday, as we bring this to a close, I just wanted to, for members, to connect some of these bigger issues you raised to some existing initiatives and sort of things to build on, as you were saying. On the sharing of information, the commission and most other state agencies have been all in on Justice Network, on JNet for many years. And so there's certainly an opportunity to build that out, to look at other kind of information to share. Most of the state agencies, including health and others, are part of that. And it usually boils down to, what are you allowed to share and so forth. But I think it's a really worthwhile endeavor. So I think there's a platform there to work on. The commission has clearly done a lot of work with risk and needs, both at pretrial and beyond, and we'll talk a little bit more about that later. But I think just trying to sort of figure out how you can identify issues to intervene in a positive way to help an individual, I think just makes a lot of sense. And probation departments are really, I think, expanding their toolbox and really getting much better at doing this in a really helpful way to keep the person in the community and safe. So something great there. The sequential intercept model, which PCCD took a lead on, a decade ago, of trying to meet with counties and map through the process in the county where there are these, critical events where you can decide, are you going to prefer the mental health or drug and alcohol system, or are you going to prefer the criminal justice system, and trying to really favor treatment over confinement. So I think there's that. And then Representative Stevens' point about, a co-sponsorship for JRI 3, in JRI 2 and JRI 1, both times there was a lot of discussion about how undeveloped our pretrial space is, and really sort of splintered. And so I think there's always been talk of that, and it's great to see some efforts to sort of move that along, because I think there's a lot that can be done earlier in the process to bring about positive change. So thanks for that. Are there any other final comments for DA Sunday? I know he has to get to another meeting, and we have a couple other agenda items.
I don't see anybody else unmuting. I think we're good.
Okay. Hey, thanks, Dave. Really appreciate it. Were there any final things you wanted to say?
Oh, Professor Rago unmuted, so I think
Oh,
maybe
sorry.
he has something.
No, I just wanted to say thank you. That's all.
Okay. Thank you, DA Sunday. Executive Director Bergstrom, you want to carry on to the next item?
Sure, thank you. We're going to move on to discussion of the model pretrial domestic violence risk assessment tool. As some of you know, but we do have new members. Back in 2018, the commission was given a mandate to create or to identify a model pretrial domestic violence risk assessment. And this was different than our typical mandates of adopting guidelines and things like that. The commission was given 2 years to identify basically a best practice, the best model to be available to assist minor courts, magisterial district judges, or other individuals setting bail, initial bail, to provide them with a mechanism, a tool that could be used in domestic violence cases to try to protect the individuals in the community and try to move the case forward in an appropriate way. What was very clear about the mandate we received was we were coming up with a model, and then it would really be up to each county to decide if they would decide to move forward with that model, or if they decide to try something else, or if they decide to do nothing. So the decision on what to do at pretrial related to domestic violence and risk was really going to be determined by the president judge of each county. So the commission had this 2 year requirement to review and come up with a best practice. And so at the end of the 2 year period, following public hearings, following a lot of meetings that are documented in the materials, the commission agreed to or approved a model called ODARA, which is the Ontario Domestic Assault Risk Assessment. It's the leader in the field, certainly developed in Ontario and used in Canada, but used in a lot of places throughout the United States. And we've spent a lot of time looking at that, talking to individuals who conducted research on outcomes of the ODARA, and talked to people about implementation of it. Had a really great roundtable at Duquesne Law School to review this and bring in outside experts. So, did I think a solid job of trying to review this and come up with a recommendation. And during the public hearings, we heard support for this model. And so the commission a year ago, during our March meeting, approved this as the model. And then COVID-19 came about. And the thing is that the plan was to submit our recommendation to the General Assembly. We didn't have to adopt, it was just approving and submitting. And then in effect, inform judges that that was the model that we suggested. But all of the action would really be with courts to decide what they wanted to do. And as you know, the courts have been interrupted, disrupted because of COVID. And so the last thing sort of on the list was adding yet a new program. One of the other complications about the legislation was, and this was all for the right reasons, good intentions, but the legislation also required that if a county was going to adopt a pretrial domestic violence risk assessment, the commission should do a validation of that study. So it sort of linked together the decision at the county level to move in the direction of a risk assessment with the commission doing a validation. And the sort of the technical problem is to validate something, you need good data, good information, and you need sufficient numbers that you're able to do that. And so the problem the commission envisioned or saw was there may be some relatively small counties that would be very interested in doing this, but we wouldn't have enough data for we'd need years of data to validate the use of an instrument. And since they had not been using the instrument, any kind of action wouldn't happen for years into the future. And so the commission discussed some of the limitations of the legislation around that validation, and also recognize that the commission doesn't have all the resources in the world. And so if every county wanted to get on board, but every county picked a different tool, a different assessment instrument, the commission would be spending all of its time just trying to validate each county's studies, and that wasn't very practical. And so the commission talked about ways to suggest modifying the existing legislation to achieve the ends that were identified, but perhaps in a more systematic way. And so what the commission talked about was, instead of the commission serving as a validator of all instruments, maybe what the commission could do is agree to be the validator of this model that we're recommending, ODARA. And what we could do is we could set up a data collection system through SGS Web, through our sentencing application, that any county that decided to get on board, that wanted to pursue this, could in effect sign up, and they could be providing the commission with the information that we would need for validation. And it wouldn't be a mandate on them, because the counties would decide if they wanted to do this or not. They could still move in a different direction. It's just that the commission would not validate that. And the benefit of this approach is, number one, we thought the model was the best of practice, and we wanted to promote that. Number two, we could build up a data collection system so that instead of each county having to do that, we could, in the aggregate, collect that information from all counties that are interested in participating. And then number three, because you'd have more counties involved, you would have bigger numbers that you could use for a statewide validation. So if this was being used by any county in the state, you'd be validating for the state. So that was sort of the plan. There was one other limitation, I guess, or a couple of other limitations that got into sort of the weeds of validation. And one of them was that when the commission staff looked at all of the sort of best practices for this kind of tool, what we found was that the sort of the scope of it, the target of domestic violence was around intimate partner violence. But the legislation that we have in Pennsylvania was very broad. It involved, family members, basically, family or household members. And so the commission suggested that, there may be all kinds of assessments done at different points for different reasons. But if we were going to recommend a single model and we were going to come up with a process that would help counties to implement that kind of model, then it made sense to try to focus on the individuals or the circumstances that most of these assessment models focus on, and that would be intimate partner violence. And so the final thing was, in the original legislation, there was also appropriately consideration of, within the validation, of things like race and economics and things like that. Very important. But the language was such that it was written in sort of absolute terms. And when you talk to statisticians about putting that in practice, there was never a way for the commission to achieve that outcome as part of a validation. So those were all of the issues that were in play when the commission was approving ODARA as the model. And so sort of complementing the ODARA model, the commission approved draft legislation that would modify Section 2711 of Title 18 to address some of these kind of concerns. So again, trying to honor and preserve the intent of the legislation, trying to promote the availability of this, trying to streamline some of this, but also trying to redefine some things to make sure that it was achievable. And so those were the two different aspects of the pretrial domestic violence risk assessment that the commission approved a year ago during this meeting, so March of last year. And then everything was on hold. And so we're in a new session of the General Assembly, and hopefully we're coming out of the COVID restrictions. Courts are starting to operate a higher level, and we hope that continues to improve. So we thought this might be an opportunity to now submit this information. And what we had talked about before was to send a memo to the leadership of the House and Senate, just to indicate that, here's our report, here's our recommendation, and here are our recommendations about changes in legislation that could help facilitate this moving forward. And in tandem with that, then also sending a letter, whether at the same time or sometime later, to all president judges, informing them of this model. And if they start to think about it or want to talk about it, the commission staff could engage with them to have discussions about this. So I wanted to put all that out on the table, and sorry for the long explanation, but because we really didn't close this. COVID closed our work on this, and we, I think, have an obligation to at least formally pass on the information to the General Assembly and inform judges, because that was the intent of the legislation. But I think it's also, as the commission discussed last year, an opportunity to try to modify it so that it really can be done, that it can be used, and that we can make sure that we're having all those safeguards in place that were intended. So with that, I'm going to throw it back to Judge Bernstein, because I just wanted to put it sort of on the table and provide an opportunity for some discussion, and I guess in hopes that we can just move this forward, start up again, start where we left off last time around. So Judge, all yours.
If anybody unmutes, I'll kind of scroll through to see if anybody has any comments or questions. No, I'm scrolling back up. I don't see anybody with any questions. Representative Krajewski.
Yeah, thank you. I just had one question in regards to looking at the slide here. the ODARA tool is specifically for predicting future violence against intimate partners, but the statute also, it's a wider statute for what qualifies under domestic violence. So are there any plans to address that discrepancy around about like what our statutes, what's identified as domestic violence versus what the tool actually applies to?
Sure, that's a great question. It's one of the things the commission talked about last year, because when we started our inquiry, when we got the mandate and we had 2 years to look into things, the first thing we did was look at current practices, because we were not building our own model. We were, in effect, adopting a best practice, trying to find a best practice. So we looked around the country and clearly internationally to find what those best practices were. And what we found in that, through that investigation, was there were no good models out there that had that broad a definition of family or household member. There were none there. And that may be very important, but we couldn't find something like that. And that definition is very broad, especially if you look at the statute and how the statute defines family and household member. It's a lot of people and a lot of different circumstances. So it's almost like you're doing multiple assessments of different kinds of outcomes. Because intimate partners would be a subset of that, but as you said, much broader than that. So what we thought was, especially because there was nothing in place right now, or nothing systematically in place, the better thing would be to start with a trusted and good practice, adopt something that we know has a good has a good history and has been validated, and use that as the starting point. And then once we get sort of a foot in the door, if it's working well and we have the opportunity to expand, let's work with developers and others to look at that. But it was just like biting off a lot, and we weren't even sure how we would do it, because it would really involve building a model. And we went through that in other areas, and it takes decades, and it's a lot of work. And again, this isn't a situation where we're creating something. We're just identifying a best practice, and then it's up to the counties to decide whether to opt in or opt out. So hopefully that explains that.
That does. Thank you, Mark.
Great, thank you.
Any other questions?
Just a comment, if I could.
Sure.
Yeah, Rep. Krajewski and Senator Street. So this, I've raised some of these issues because these are going to require some legislative changes on really technical stuff. And so I've raised it with our Judiciary Committee staff, to the extent that, maybe we can huddle together to figure out a way to move this process along. It just, it's just technical stuff that I know, sometimes it's pretty far in the weeds. And so it's just a challenge trying to, I even tried to start to put together a co-sponsor memo on these changes, and I can't figure out how to, how to explain it to folks in simple terms, like what we're dealing with here. So I'm open to any ideas you guys might have on how we can get that across the finish line to make these changes so that we can be consistent with the statute, or make the statute consistent with what we can plausibly do. Either I'm open to ideas now or later, whenever you want.
Yeah, I'm interested. Maybe we can talk about how to put together what a co-sponsor memo would look like, and how to maybe we put together a briefing for members so we can sort of let them know what's going on and move something through the process.
All right, we'll circle back maybe offline on the legislative side and see if we can all get together and figure out a way to get this forward, move this along.
Absolutely.
If I could just add one detail, and as the chair said, we can get into the weeds pretty fast on this one, but one detail that was in the original bill, which makes all the sense in the world until you try to do it, and that had to do with the focus on economic bias. We want to make sure this is fair and neutral, and it doesn't matter if a person has money or not, that it's sort of operating the right way. But to test that, you need data on, how much people have, whether they're, whether they're employed, and if they're employed, how much they're making, what they're, you can just see that, it makes, you want that as a principle, but how do you test it when you're validating something? And that was really a struggle. We don't have access to revenue, and we don't have access to labor data. And whenever you're doing this, it's not only the people that you're applying the instrument to, it's also a sort of match sample or another group of people that you're not applying it to. And so we would need, good financial information on a lot of people, and we just don't have that. So maybe there's a way to capture some of the information. Does a person have a public defender? Is the person on assistance? Is there, whatever? There may be some mechanism, but not to the point of validating an instrument with that as a standard and having a really high bar. And that's where I hope that you all can think about, how do we achieve the goal, which is exactly what we should do with if we have access to that information.
If I may, Mr. Chair. There are ways to deal with that kind of data in the aggregate. For instance, Department of Education does things around addresses and the percentage of children receiving free and reduced lunch given in the zip codes in which they're living, and there are extrapolations that can be made in that way. And the Department of Ed has information. So if without having to do a census sort of thing on each person, there's economic data that can tell, like, if you're living in the 19121 zip code, what are the percentage of children in that zip code who receive free and reduced lunch? And we know that there are certain thresholds that have to do. And we know that every school is required by federal law to do an assessment about whether children are receiving free and reduced lunch. And that's more than statistically significant sampling of that community. And therefore, you can do some extrapolations around the economic status of people from that. And the Department of Education data, the State Department of Education has data around each and every zip code and the percentage of children receiving free and reduced lunch in those zip codes. So there are extrapolations that can be made in that regard.
Senator, I think that's great, because that's the kind of, how do we honor that without saying it's a validation thing, which gets to very granular stuff that I don't think we can achieve. But that sounds like a great way to deal with the issue. So thanks.
You're welcome.
Anybody else? All right.
Well, thank you. I'll leave it to the legislative members to work this all out, and we stand waiting to help. I think we're going to now move to the next issue, and this has to do with the JRI-2 reporting and certification. And we've talked about this for several meetings, and we have had drafts available. And the one thing we did not, and we've shared a lot of information with counties. We ran data based on 2019 sentences reported to us to sort of plug in for each county the details we would have on reporting and certification. And we also use that to, in effect, map our data in SGS Web, what was reported to us as sentencing information, against AOPC data on all convictions. So we match those up, and we look for gaps, underreporting in our system. And so that's part of the full reporting that's required by the legislation. So, so the commission has provided all of that to individual information to each president judge, information to all criminal court judges. So we have a lot of information out there, and to others, individuals and associations, including PCCD, which has the new County Chief Adult Probation Officers Committee. So we ask for comments and feedback, and you'll see in the packet we received a feedback from the County Chiefs Association. So that we're very happy to receive that. And I think one of the things we want to be really clear about, and maybe it wasn't clear to this point, is, we're building something, we're building a model because we have to, because the JRI2 legislation required full reporting and required this certification of compliance. And so we used the sort of the letter of the law in two sections of the statute, in Act 114 and 115, to come up with this this template, this certification process that we've talked about. And I'll go through that quickly, because the missing part was, how much weight do we give to each of the factors? Because there's a lot of factors involved, and we can come up with a lot of that information, but it's really a policy decision for the commission about how much weight to give each of those. And one of the concerns that the chiefs raised and that we heard before was, we can't apply this retroactively. When we provided the 2019 sentencing data to courts, it was to give them a snapshot of, if this had been in place, what would it look like? And there were some real deficits in some counties. A lot of counties did great, but there's gaps. And so, as you know, the last year or so, Ryan and his entire team has been engaging in a big way with counties, going out on meetings with counties or doing individual Zooms with counties. And a lot of that was about JRI2, and a lot of it was about complete reporting to the commission and reviewing how they do what they do. And we continue to meet with counties to try to upgrade that. This effort's not even going to apply to 2020 sentences, because first, it would be retroactively applying, and secondly, because of COVID, that's going to be interesting information, because courts were closed and so forth. But the intent is that this application, this assessment or certification, will apply to this year's data, because we've put everyone on notice during the past year that that was the plan. And we made very clear this year in writing to judges to remind them, every criminal court judge, the importance of reporting all sentences to us, and how what they do this year could impact funding that's decided next year. So next April, we'll be looking back at this year's data and using that to determine the level of reporting in the county, and also this certification of compliance. And keep in mind how we do verification of stuff. We have a regular process where we provide information to the courts both during the year and at the end of the year, and provide them with an opportunity to make corrections or to add missing cases. So even if at this point there are missing cases not reported, we have 9 more months to add those cases in. So this is not a fait accompli. This is, the active ownership of this right now. And then next year, we'll be looking back at this year's reporting and data and using that for the certification. So with that, here's the high level view of what we're supposed to consider. In Act 114, there's a requirement that we consider full submission of data, or that PCCD consider that when they think about distribution of discretionary funding. And there's also information on certification of compliance, but a real focus there on compliance or eligibility, et cetera, under the guidelines, and that they're using programs and things like that that are consistent with their own plan. Each county has to develop what's called a county intermediate punishment plan, where they talk about which individuals they're targeting for special programs for these restrictive conditions of probation, and what those programs are. Because in one county, they may have a day reporting center, or they may have a high use of inpatient treatment or mental health services or other things like that, and that they approve that, and they target individuals in the county for the use of those resources, and they make sure they're eligible and so forth. And in another county, maybe those programs haven't been approved. Or maybe in one county, only one track program, only one court may use these programs. And in another county, it's open to all common pleas criminal court judges. So every county gets to decide its own plan. But that plan then has to be submitted to PCCD and approved. And so if a county doesn't even submit a plan, the statute says they don't get any of the discretionary money linked to that, linked to county intermediate punishment. Or if they submit a plan and there's all kinds of problems with it, and it doesn't meet the certification we're doing, then they wouldn't be able to get funding for county IP either. So they have to submit a plan, and they have to be certified to get county IP funding. So annually, there's about $18 million available, and PCCD has a discretionary distribution of that. But the threshold is you have to submit a plan, and you have to be certified by the commission. That's what will count when we get to this for next year's consideration. And then there's other money that PCCD has to distribute to county probation and parole. A long existing pot of money we call grant in aid. It used to be distributed through the parole board to county probation and parole. Now it's distributed through PCCD. PCCD, through their county adult probation and parole committee, has a lot of discretion over that distribution. But what they're supposed to do is consider a whole bunch of factors listed in the legislation. And some of those factors are full submission of data to the commission and certification of compliance. But we send PCCD the information, and they'll decide how to use that information for the grant and aid funding. And then there's going to be a new bucket of money linked to JRI2 and linked to cost savings because of JRI2. So that's new money. And there again, PCCD has discretion on how to distribute that to counties. They're supposed to come up with a plan for this, but they take into account information we provide to them. And some of the information is the full reporting and the certification. We also provide them with information on the offense gravity score and prior record score of everyone coming through the court that year. So high level, those are sort of the issues that are in play in terms of us thinking about reporting and thinking about certification. And I have listed on the slide under Act 115 some of the very specific things we're supposed to consider when we're looking at things like compliance with the guidelines, compliance with other statutory requirements, such as the requirement to consider the guidelines and report sentences to the commission, but also all of the provisions under Chapter 98, which is the County Intermediate Punishment Chapter. And then finally, there's a provision about restitution collections. And what we found from AOPC is most of that is automated through the Common Pleas case management system. So we assume that restitution collections should be a gimme because courts operate under the structures that are already placed by AOPC, and we assume that everyone will check that box because they're just working in CPCMS, and that basically directs that. So let's get to the details in the next slide. And we provided and the next slide will be an image of the one-page sheet we're talking about, but here's the highlights of it. We wanted to think about how do you rank or rate or score two different issues. One was the full submission of data, and the other was the certification of compliance. So for the full submission of data, the question is, what's the threshold? And we talked about this at the last meeting. So think about a county that has 1,000 cases a year. What should be the threshold for a definition the commission has of full reporting? So 1,000 cases occurred. There were 1,000 convictions and sentences. Is it good enough that we get 850 of those? You know, we want 1,000, you know, where should we draw the line and say, that's just, you know, not adequate. That's, you know, there's big gaps in the data, which means big gaps in us doing projections or impact analysis or distribution of funding by PCCD. If a county doesn't report a lot, we don't have the information. So, so what's the threshold? Well, you know, next year when we're looking at this year's data, it will be the first year that that money matters. That if you don't make the cut, you could lose some money. And so we thought we should be fairly generous in setting a threshold that we think most counties already meet, or that all counties should be able to hit during this year. And so, you know, we want all counties to be in the mix here. And so we're suggesting as staff that we set that full reporting for this year's data at 85%. It doesn't mean that in a year or two, we don't creep it up to 90 or 95%, because when we looked at this, we looked at counties who have, you know, reported sentences. There are a lot of counties that we would call high compliance rates, which are 96 to 100%. In fact, I think the majority of counties fall into that category. And there's quite a few counties of the other counties that are in the 91 to 95% range. You know, the 85 to 90, there's a handful of counties there, and I think we want to really encourage and promote them to this year, really look at that, spend some time on it, and try to make sure they're in full compliance. And for those that are below 85%, we want to bring them up to 85%. But if we say that they are not fully submitting the data, if they submit less than 85%, staff is recommending that that would be a disqualifier for certification of compliance, that a county could not receive county intermediate punishment money if their reporting during this year was under 85%. So that gets us to certification of compliance. And for certification of compliance, there's a lot of different factors, and this is where we talk about the weighting of the factors. We thought that, you know, the passing rate for certification of compliance based on all the stuff we reviewed would be 70%. And again, that's, you know, we're seeing all of this as a first year thing. At some point we can change those standards, but to start with, the threshold would be 70%. If you didn't get 70% on certification, you would not be certified. If you got 70% or more, you would be certified. And here's how we broke out the weighting of that. So we would look at all cases reported, and we'd look particularly at the use of restrictive conditions of probation, those county intermediate punishment programs, and use of probation generally, because that's what our mandate is about this certification. So the first thing we'd look at is, are the individuals that were sentenced in the county that year to restrictive conditions of probation eligible for that? Were they eligible by statute? And were they placed in programs that were part of the county's IP plan? So that would be the first part of that. And that would be worth 30%. So we'd look at all of the cases, and then we'd, you know, if they got 100%, then they got 30% out of 30%. And if they got 50%, they got 15% out of 30%, right? So that we'd look at that factor. We'd say that's worth 30% of the whole, and then we'd figure out how much of the 30% they earned. And that would be part of the total for the county. The second thing we would look at, which we think is the most important issue, is compliance with the guidelines. Certification really focuses on the guidelines adopted by the commission for probation and probation with restrictive conditions. And so we think that should be the focal point of certification as well. So again, looking at all sentences reported, did the court comply with the guidelines in all of the cases? If all of the cases were compliance, you get 40 out of 40. If it's less than that, then it's some percentage. And here's what we mean by compliance. It means, you know, playing by the rules. So it doesn't mean you have to be in the standard range of the guidelines. What it does mean is, if you aggravate or mitigate or depart from the guidelines, you know, the guideline text talks about providing reasons for the record or reasons to the commission. You know, those reasons could be risk needs assessment, recommended, a less serious sentence or fewer conditions. It could be that, there's drug and alcohol dependency and there was a clinical recommendation for some treatment in lieu of incarceration. So there's a lot of things that can happen that mean the sentence isn't in the standard range, but it's in compliance with the guidelines. The court is abiding by the guidelines, applying the guidelines and identifying reasons. So that's what we're looking for. So that second one, 40% of the whole. The third category is related statutes. And there are, and these are any other statutes that relate to sentencing. So considering the guidelines, reporting sentences to the commission, considering the County Intermediate Punishment Plan or Act, which is Chapter 98, all the eligibility criteria there, all that other stuff. So there's a lot of other statutes out there that relate to sentencing and the use of restrictive conditions. And here's where we say that is only worth 20%, but we're going to have two disqualifiers there. The first is if you are not certified, if you have not reported at least 85% of your cases, you are not certified. So it's a disqualifier. And the second one is if you didn't submit or have a plan approved by PCCD, you're not certified. So those are the two disqualifiers. But if you've submitted at least 85% of the cases and your CIP plan has been approved by PCCD, then those are off the table and the related statutes are worth up to 20%. And then the final thing is that restitution collection. Remember what I said from our discussions with AOPC, this is built into the system. If a court orders restitution, this mechanism for any payment being distributed and part of it going to restitution is already built into CPCMS. And if that's the case, then every county should be 100% on this because it's an automated process that's basically controlled by AOPC's programming. So this is like a gimme. So it's worth 10%, but it's in the statute. It's important to consider, and that's why it's there. So you can see we have 30% for the eligibility and programming, 40% for guidelines compliance, 20% related statutes, and 10% for restitution. And we have those two disqualifiers. So if a county failed to, let's say only got 20 out of 30% on eligibility and only got 30 out of 40% on the guidelines compliance and only got 10 out of 20% on related statutes, the county would still hit 70% and would be certified as compliant. So all of those add up to 100%. And what we're saying is after we do the assessment, 70% is the threshold. If you're less than 70, you're not certified. If you submitted less than 85% of your cases, you're not certified. And if your CIP plan was not approved, you're not certified. So those would be the standards we would put in place. It would be for this first year, and then the commission would review it. It would apply to the 2021 data, and so we'll decide next year. And then this is what we submit to PCCD. We would tell them each county's certification, whether they're certified or not. We provide information on the full reporting, the percentage of cases reported to us, and we provide the other information that Act 114 talks about in terms of OGS prior record score and other things like that. And then PCCD is responsible for deciding dissemination or the distribution of funds that they have under that statute. So I know that was a lot of talk. And again, Ryan, if we could just put up the next slide. And this is the one that was included in the packet, but it's the one-page sort of documentation of the information we provide to counties and the certification process. And we've done a draft of this where we sent it to all the counties based on 2019 data. We'll do that again with 2020 data, and we'll do that with 2021 data at the end of the year, and counties will have 30 days to modify and update it before we start to do the analysis. So there will be plenty of opportunities to to make sure that you're getting up to speed. The reason we wanted to bring this to you today, and hopefully that you consider approving it, is because we think it's important to not only tell counties what we're looking at, which we've already done, but also to tell them what it's worth. You know, how much weight we're going to give to things and what are the thresholds, so that we can really work with counties and maybe incentivize counties to fully report and to at least consider the guidelines, you know, play by the rules, basically. We think that's the purpose of this in JRI 2. We want to work with counties. We're not looking to punish or penalize counties, but you know, we've had guidelines for a long time, and the reporting requirement has been there all along. And if there's underreporting, this is one opportunity to try to correct that, work with counties to improve on that. So with that, I'll turn it back to Judge Bernstein for any discussion, and then this will be a voting item on the quarterly meeting agenda.
Are there any questions or any comments, Judge Marsico?
Mark, as you know, there's a lot of concern about this, since we talked about it last, especially with the funding component. Will PCCD, if the commission does not certify someone, is it a given that PCCD will withhold funding, or do they have discretion as to what they will do?
They have discretion in 2 of the 3 areas. So the County Intermediate Punishment Statute Act or Chapter 98 of Title 42 clearly states that if our commission does not certify a county, that county cannot receive county intermediate punishment funding. So that's the $18 million a year. But the other 2 buckets of funding, the grant and aid funding and any kind of JRI 2 funding, is discretionary to PCCD through, they're supposed to look at a lot of factors that are listed in the statute, but they have discretion. So even if we don't certify a county, even if county is underreporting in a huge way, that's going to be the discretion of PCCD.
The counties, I know that we took a look at it 2019, and there were several that were below the 90%. I guess I got a couple concerns with that. What if it's a one-year blip? You have a staffing issue in a county, with the person that's responsible for submitting them for whatever reason.
Yeah.
But the county was otherwise good the last 3 or 4 years. Is there any consideration for something like that?
Sure. 2 things. First, we said, because of looking at the counties and where they fit in 2019 and thinking of that as generally a baseline. I mean, we couldn't count all counties that way, but that's why we went with 85%, because I think that does capture some of the counties that were sort of at the edge, but there are some counties at less than 85%. And we think, there's efforts to try to move them up to at least 85%. So I think that was a recognition of some of the discussions during the last meeting about where do counties fit right now. The second thing is there is going to be an opportunity for counties to continue to update this, and at the end of the year to add cases if they're missing. And I think one of the things we've discussed, and I think it might get to your point, is perhaps we do a mid-year review, that after all the June sentences have been submitted, so in July or August, we give the county a sort of a mid-year report on the percentage of cases and that, so that the county, if there's deficits, they know about it early and they have an opportunity to take action to correct that.
Well, I think that's a good idea. I know here in this county, we did have an issue when these numbers came out, and I've been assured that the last couple of months some redirection of staff to get stuff done has occurred. So I think that would be helpful. How many, as I understand it, there were 6 counties that fell below the 90% threshold. How many fell below the 85%?
Yeah, I'm going to see if Ryan's available. I don't have that sheet in front of me, but Ryan might have that information.
Yes, thanks, Judge. I think the number was 7 below 90% and then 5 below the 85%. And if I could just respond to one of the points, clearly working with the counties and providing these end of the year reports and to Mark's suggestion of a mid-year report makes all the sense in the world. And we also have to keep in mind that counties have access to reports available at all times in SGS Web. And so part of our role has been in the last year and certainly the beginning of this year, communicating to counties that ability to run those. They could do that on a quarterly basis after court terms come through. But I think to your point, Judge, and from the Education Outreach Unit, we can step up and make sure we're reminding counties sort of informally with our county contacts throughout the year, and particularly around 2021, so that we're not in a position with 5 or 7 counties below this threshold, at this time next year.
And then I guess to that point, would it make, I'm just throwing it out there as a discussion point, would it be something to consider maybe an 80% in 2021 and then raise it to 85 in 2022? Would that capture some of these other counties? Are they close or are we way below and not there?
Well, I get, that's going to be a decision by you, by the commission, because it's really a policy decision. I think one of our concerns is if we basically accept sort of the status quo, we're not moving the ball at all. And
Gotcha.
we've been working the last couple of years to try to really, bring this to people's attention. We are seeing a lot of action by counties. And I just think it's, we have to at some point, make sure we're showing some progress, because, I mentioned the example of 1,000 cases in a county, and, if a county only submits 800, what's missing and how's that impact our?
I agree, Mark, but I just am concerned about, and this, the chiefs put it in a letter, and I thought about it even before I read their letter, is effects on things like treatment courts, in those counties that don't get funding. And I agree, I mean, I've heard about this issue for at least 10 years, with counties not complying, with the guidelines. And I guess I'd liken it a little bit to, I know on PCCD, they talked about fingerprint compliance with police departments, and they've raised that. And I can't remember if that was through withholding funding or not. You might remember, Mark. I don't know, but I know that was, it sort of seems like the same thing. You got to have some mechanism out there to get compliance. And we have talked about this for at least a decade. I've only been on the commission a short time, but, in my previous role as DA, I know it was always an issue. So, okay, just those are the questions I had. Thanks, guys.
Sure. And we'll bring this. I know we're getting towards the end of this meeting, and we didn't even get to the academic panel. We can roll those into the policy part of the regular commission meeting. So I'm going to turn it back to the judge if there's any brief comments, but we can.
Yeah, I had
the regular meeting.
I'm going to hop in real quick because I see 2 people. I have Judge Tucker and Senator Street. So maybe Judge Tucker and then Senator Street.
I'll yield to the senator.
Yeah, I'll try and be quick. Do we know which counties were in non-compliance or below the 85%? And do we know, or is there any profile for counties which fall out of compliance, or is it just sort of random?
Yeah, we do know, and I think in the materials, certainly in the last meeting, and I think in this meeting, but if not, we can get that for our upcoming meeting about the county breakout. I'm not sure that there's not anything sort of stands out there. There are some that are very rural, some that are very urban. So I'm not sure, it's just more internal practices within the county. And we're doing a lot of work to try to work with those counties to address those issues. So I think, I don't know that there's anything specifically that stands out. If we don't have that in the materials for this meeting, what we'll do is make it available so that we can show you during the policy discussion or the unit discussion a little later during the regular business meeting.
Thank you. That'd be helpful.
Judge Tucker, did you have a?
Yeah, I always thought I was unmuted. Sorry, Judge Tucker.
Yeah, no, that's okay. That's okay. I think one of the also concerns is notification to the counties of the requirement or the request that they submit this information. Oftentimes in counties, in large counties such as Philadelphia, where you have somewhere in the neighborhood of maybe 30 or 40 judges doing criminal cases, and oftentimes those judges are placed in the criminal court when they first go on the bench. They have no idea that they are supposed to do this. Oftentimes the memo or the information may go to the president judge, and it may be sent out maybe once, and that may be before the judges take the bench doing the criminal cases. So I think an enhancement or a more robust notification will probably help in getting these requirements done.
Thanks, Judge. And that's a really good point. And one thing that we've tried to do last year and again this year is have an up-to-date email list from the AOPC of criminal court judges that we could send information directly to each criminal court judge, as well as the president judges or administrative judges.
And additionally, as you well know, it's a very complicated procedure to put this information into the system.
Yeah.
Candidly, I don't know how to do it. I rely on my staff to do it. And sometimes they hit a glitch and think they submitted it. And for whatever reason, it was not submitted. And they may look back maybe 30 days afterwards, and there's 40 or 50 cases that are just sitting there that they didn't hit send or didn't hit whatever button, and it was not submitted. So I think we really need to look at the whole gamut of the reporting process, from notice to the mechanics of how this is done while we're looking at this.
Sure, I think that makes sense. And as you know, Judge, in thinking about new guidelines, we're also sort of on a parallel track of rebuilding the application. And part of that is about, further automation and streamlining. So it is, it's an easier process for the end user as well. So I think that's a great point. Again, it's going to be the commission's call on what you do and when you do it. But the legislation was enacted in 2019, and staff is trying to bring, keep this moving along. And so we can talk about it at the full quarterly meeting.
Can I ask one quick clarifying question?
Sure.
Great, thank you, Margaret. Just so I have it right, in regards to the requirements to not have funding pooled. So one is that they must have a CIP. Another is that they must have at least 85% reporting numbers. And then additionally, they must also reach 70% certification compliance based on the percentage breakdown of the weighted score.
That's
correct?
That's exactly it. So the 70% takes into account all the factors that are listed in the legislation. And then the two disqualifiers for certification would be reporting less than 85% or whatever threshold the commission sets, or not submitting and having approved a CIP plan.
So a county could have the 70% compliance, but still fail because they haven't reached the 85% reporting.
That is correct. Yep.
Okay. Got it. All right. Thank you.
And Rep, one of the reasons that's the case is the statute actually lists those two things separately. So certainly reporting relates to certification, but the separate issue, the definition in the statute of the term is full reporting. And what is full reporting?
Are there any repercussions for, I know you have the different categories of high, medium, low reporting. I mean, obviously there's just, you have to reach the 85% threshold. Is there any other incentives or things around like being at medium or high, aside from just having more reporting on the record?
I guess it's aspirational, but it's however the commission might want to use it. The reason we had those breakouts was, in an aspirational approach, you would want full reporting to mean something like 95 to 100%. And so we want to recognize that, and to the degree either this commission or PCCD wanted to incentivize or something like that, having those breakouts might be relevant, but for the most part, that doesn't have, it doesn't have much of a role unless when we figure out the percentage of reporting, how many points you get for that, that might, come into play.
Thank you.
Any other questions or comments? Executive Director Bergstrom, are we going to take a bit of a break before we segue into our next portion?
I think maybe we could take 5 or 10 minutes, start at either 11:15 or 11:30, whatever you and the chair decide. And then we will make sure that we cover the academic review panel and the vote on JRI 2 or further discussion during that meeting.
How's 11:20 as a middle ground?
There you go.
All right.
All right, so we'll see everybody back here at 11:20 a.m.